Sorry, Professor, I explain something for my students in bahasa. Kalau memanggil Profesor Trakman itu memanggilnya bukan Profesor Leon ya, Profesor Trakman. You understand? Oke. Jadi bukan menggunakan nama depan. Terus seperti biasa nanti Profesor Trakman akan memberikan presentasi, tapi mungkin kalau beliau lelah dia berhenti, Anda mulai bisa juga untuk memberi mulai memberi ini pertanyaan juga boleh. Pertanyaan bisa diajukan tertulis maupun lisan. Kalau tidak bisa menggunakan bahasa Inggris, boleh menggunakan bahasa Indonesia. Nanti akan saya terjemahkan. Baik, Mbak Dian sudah bisa streaming.
Bu. Oke.
Siap.
Ini sudah streaming dan saya record ya Bu ya. Silakan bisa dimulai.
Ya, ya Rosa boleh memberikan pertanyaan lisan ya, maksudnya langsung boleh nanti setelah Profesor Trakman. Okay, so now let us start. Okay, good morning my students and my fellow lecturers in Brawijaya. Good morning Dr. Alisa Faat, the Dean of the Brawijaya Law Faculty. Good afternoon, Professor Leon Trakman, Professor Emeritus at the University of New South Wales Law School, Australia. I also welcome Professor Anselmo Reyes and Dr. Nobumichi Tekamura from Japan. Some of us must know them because they were involved in program 3-in-1 back in 2018. So now let me invite our Dean, Dr. Alisa Faat, to give his welcome speech and to open this guest lecture. It is your time, sir.
Thank you, Bu Afifa. Dear Professor Leon Trakman, Professor Emeritus from University of New South Wales, Australia, dear all participants, colleagues, lecturer from Brawijaya University and other university, all students, Assalamualaikum warahmatullahi wabarakatuh. Good morning, ladies and gentlemen. Alhamdulillah, thank to the Almighty God for the abundance of health for us. Hopefully, everyone in here always healthy and may continue to carry out our activity. And every single state right now, including Indonesia, currently have a heavy burden. In addition to protecting the safety of the citizen from the coronavirus, the states must also push economic growth to prevent a recession that may have a worse impact than the COVID-19 pandemic itself. The role of the state will be even greater, including in negotiating with corporations that will invest in Indonesia. The state is certainly bound by regulation and also public aspiration, which are not always in tune with the interest of the investor. Conversely, investors have the choice of the country that is the most profitable for them. Of course, a certain strategy is needed to resolve negotiation and dispute that arise. I believe that this guest lecture held today will provide enlightenment in knowledge regarding dispute between state and investor. This is very important in order to improve the graduate competencies of Faculty of Law, Brawijaya University, to be able to take part at the international level. I would like to express my gratitude to Professor Leon Trakman for your willingness to give lecture here. And I hope this lecture is a starting point for active cooperation between Faculty of Law, Brawijaya University with University of New South Wales. So we ask actually Professor Leon Trakman might facilitate the cooperation. Thank you again, and thank you for all participants and also for committee, especially Bu Afifa for organizing this guest lecture. Thank you again, and Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you very much for Dr. Alisa Faat for taking time to open this guest lecture. We really appreciate that. Perhaps Prof. Leon Trakman also want to say something in replying Dr. Alisa Faat, but it's up to you.
Thank you. I would actually. I think the Dean's comments are very appropriate, and perhaps as a preliminary comment, which in effect reflects what he's said, there is a tension now, particularly in the coronavirus era, between domestication. States are increasingly looking inward, largely because of the disruption in the international community, and that's beyond Trump's United States. But there's a general preoccupation with withdrawing from the international community, what I would call territorialism, inward looking. So that's one side of the equation. The other side is we live in an interdependent world, and it's extremely important to recognize that interdependence, being outward looking. And that is the current tension with regard to international investment. You need to improve your economic position by expanding your imports and exports. If you're unable to do so, if you take a protectionist view, then very often, most often, your economies do not grow, they shrink. And that's the current position we're in. There's the political, social, and economic need to both protect, as your dean says, your state, your local interests, your public interests, and at the same time to recognize that looking outside, attracting investment and sending investment elsewhere is also in the state's public interest. And that's the particular situation we're in now, with everybody claiming force majeure, superior force, the pandemic we did not understand, it's beyond our control. All of that is true. But at the end of the day, we have to find solutions. And that's the dilemma currently. I think your dean hit the nail right on the head.
Okay. All right. So thank you so much for your kind response to Dr. Alisa Faat's speech. So, well, that is now up to Dr. Alisa Faat if he would like to stay or continue with his administrative jobs and other kind of works. Yes.
I still monitor it.
Okay. Yes. All right.
Yeah.
Thank you. So, okay, so now it is time for Professor Trakman to deliver his lecture. We actually have time until 12:15 Malang time or 4:15 p.m. Sydney time. But of course, if for certain reason we could finish this guest lecture earlier, we could also finish it earlier. Finish it earlier, but we will see later. So before Professor Trakman starts with his lecture, I will briefly read his resume. So Professor Trakman is a professor of law at the University of New South Wales in Sydney. He has extensive experience in international arbitration and is trained as an international commercial arbitrator and mediator. He also served in a number of tribunals of North America Free Trade Area. So now let us listen to his presentation. So in the meantime, if Professor Trakman allows us to deliver question, just he will pause and open question and answer session. So we take it, relax basically. So you may start, Professor Leon Trakman, while I'm sharing your presentation in the in the Zoom. Thank you.
Thank you very much, Aviva. Is it possible that I can share the PowerPoints on your screen, or is that
Yes.
not possible?
Possible.
Can I share the PowerPoint? Can I see the PowerPoint?
Yes.
Your PowerPoint.
Yes.
Okay, let me just find it. Is that at the bottom of the page? I'm trying to find the PowerPoint.
Just a moment. I could do it for you like this. Just a moment.
Okay.
Hold on.
Okay. Thank you.
Could you see that?
It came in for, yeah, there are, no, it came and it left. I've had the same.
Mahasiswa, could you see the PowerPoint of Professor Trakman? Yes.
Hang on, I've got
okay.
it.
My student could see that.
I've got it again. I've got it again. It came back. Okay. I can begin. Let me just go to the beginning. Okay, with regard to finishing, I know that most of you would like to go on for 5 hours, just joking, but I will definitely finish within the time available, and I would like to have questions and discussions with you, if that's okay. Right now I can't see your chats because it's covered by your faces, but perhaps as we go along, I can somehow get access to that. Let me just try with the chats. Okay, I'll find a way. Okay, look, with regard to how to proceed, let me start off with a broader picture and then work my way to the more specifics. What we currently have, and this has been in existence for the last 40-ish years, is we have a series of agreements, bilateral investment agreements, free trade agreements, and an attempt at a multinational investment treaty, which never occurred. It failed, promoted by the French, but it never quite happened. So we do have bilateral free trade agreements. We also have regional and multilateral, but we do not have a multilateral investment agreement. The biggest problem, and it remains that, is a division among states as to whether there is greater benefit to have a regulatory regime that is international in nature rather than domestic. And that's what we will talk about. The key issue is domestic states, largely from developing countries, are very interested in ensuring that their outbound investors are well received in so-called host countries. So, for example, the United States wanting its investors wanting to invest in Indonesia wanted to ensure that they are securing the appropriate benefits that they expect from that particular trade, that particular investment. That is the issue for many developing countries. They want foreign investment. They want exporters from the United States, from Europe, from Australia to invest in the Indonesian economy. By the same token, they also want to protect the interests of the state. So investors are needed to grow the economy, for employment, for the development of society in Indonesia, but at the same time, there's the interest of the state to protect itself, its national security, its environment, its financial system from foreign investors that might dominate or undermine the interests of the state. One of the risks to foreign investors, going back to the other side of the coin, is that they are exposed to what we call expropriation or government takings. So, for example, a large company, and let us go to the Churchill mines episode, a coal extraction environment, which you've read about, which is effectively run by a local company, but with all its investments coming from, among others, Australian and business investors. They are the shareholders of the Indonesian country. The issue then is how does Indonesia protect itself from these foreign investors in what effectively amounts to a localized company where they effectively avoid, in this case, fraud. There was fraudulent documentation which was held by this coal extracting company, largely licenses, permissions to extract coal. These were forgeries, unsigned or questionably signed in particular. How does the state protect itself? And in this particular case, Indonesia, in effect, withdrew the licenses on the grounds that they were fraudulent. The result was there were several actions. One action brought by the company itself, the coal exploration company, and then a further action that went to investor-state arbitration, and that was brought by the British and the Australian investors. The upshot of it is, we'll talk about that later, is the investors, the claimants, lost, and the Indonesian government won. But there are a lot of things that happened around the case, because cases have a lot of effect on the regulatory system, and we'll talk about that later. So on the one hand, we want to protect as best as we can. I'm just going to go back a slide. I jumped ahead. We are going to want to protect as best we can the interests of, I don't know why that's, sorry, I'm just trying to get back a slide. It's locked. Let's see if I can see that. As we want to protect as best we can the interests of the foreign investors, i.e. their ability to engage in the state with the maximum of freedom reasonable, and that means that they should have access to resources, that they should not be subject to what we regard as a violation of due process, the rule of law, effectively having licenses taken away from them without due course in this case. Now, the court said, the arbitration tribunal said there was due course, there was fraud. But the foreign investor would say, but it has to be properly investigated, it has to be transparent, they should have a right to counsel, a right of hearing, the case should be decided on the merits, etc. And of course, the tribunal said all that happened did happen, but they lost. So the state, Indonesia, won. So that's the basic argument. The argument that's advanced by the foreign investors is they want to have the right to invest freely without having their investments undermined, expropriated directly or indirectly. And the loss of a license is an indirect expropriation. Now, the key issue very often is the argument of state sovereignty. This concept goes back to the 1600s. It's the idea that with the development of the modern state, and this is essentially Western liberal states in the 16 and 1700s, was complete autonomy to decide upon all matters affecting that state and its citizens. That is the traditional concept of state sovereignty, autonomy over all matters relating to that state and its citizens. The issue then is, what happens if there's a risk to the state which is regarded as affecting its fundamental interests, a risk that undermines its national security, a risk that undermines public health, such as the current COVID environment, a risk that undermines the economic stability of the country, such as the fallout of the COVID virus now, a risk involving the environment, which can impact on health, and also the ability to maintain operations, for example, through the use of fossil fuels, which is of fundamental importance. In the case of the issue of tobacco products, this has become very controversial in two cases. brought by Philip Morris, which is a large, in fact, the largest tobacco company in the world, that is headquartered in the United States. And two countries, Australia and Uruguay, both decided that they were going to introduce regulations to alert the public that smoking kills. So there was local regulations passed that stated on the package by government regulation that you are warned that smoking kills, detrimentally affects your health, whatever the wording is, it was stated in the regulations. The argument of these governments, Australia and Uruguay, was this is to protect the public interest against serious health hazards that could affect their lives, the quality of their lives, their ability to work, their ability to enjoy their lives, and the ability to stay alive. And this was reflected in the statement of Dr. Margaret Chan, who was Director General of the World Health Organization, the WHO, which is very controversial right now because they are under pressure because of US withdrawal. That may be changed over the next 2 months. But the issue is, she says, we need to allow states to protect their public from a product that kills, and that is cigarettes. And we need to be able to do so without allowing tobacco companies to use arbitration claims under agreements, treaties that allow them to undermine the sovereignty of states to protect their citizens from these threats to their health. And the case of Philip Morris versus Australia and the case of Philip Morris versus Uruguay are both investor state arbitrations where Philip Morris, international cigarette manufacturer, sues these states on the grounds that they have, through their regulations, requiring warnings to buyers of cigarettes and other tobacco products that cigarettes can kill them. Now, Philip Morris lost in both cases, and we'll talk about that a bit later, but it is significant in setting a stage between two extremes. On the one hand, the state needs sovereignty, and on the other hand, there needs to be some control, i.e., states cannot go beyond limits. So far, the states have won all the cases we've talked about. They won the case against Churchill. They won the Churchill case against Indonesia, and they have won the Philip Morris cases on different grounds. Okay, now the next slide is, do we have the next slide? I'm sorry, let me just see if I can get you to the next slide. Can anybody click me ahead? I seem to be locked on this, so I don't know why. Can anybody click the slides ahead?
Yes.
Okay.
Mahasiswa bisa melihat slide-nya? Bisa? Okay. Yeah, now it is court versus ISDS, Professor.
Okay. A big controversy that has a long history, and I'll try and deal with it briefly because it's something that I've had quite a lot of exposure to as a arbitrator and also as an advisor in matters dealing with arbitration, is the question of the choice between courts, domestic courts, and investor-state arbitration, i.e., do states agree in their treaties that disputes between investors and states, host states, states in which foreign investors invest, should those matters be required to be decided by local courts, or should they be decided by international bodies called investor-state arbitration tribunals, ISDS, International Investment Solution, Investor-State Dispute Solutions. In effect, should we revert back to the days before ISDS where domestic courts decided? Now, if you go back far enough to the old days, 18th and 19th century, matters were not decided by domestic courts, but by so-called diplomacy. If, in fact, a developed country like the United States, or let's say the United Kingdom with a giant empire, if they had an arrangement with a country in Africa or Asia or Latin America, and that country terminated the investment relationship with a British investor, then the matter might revert to diplomacy, i.e. the governments might themselves engage in a solution. Now, very often, this was not really diplomacy, it is what we call gunboat diplomacy. In other words, the rich and powerful British government would effectively present ultimatums, demands, to the African country, Bolivia, Ecuador, the Argentine. They would effectively make demands, and because they were dominant, they succeeded. That was replaced as the modern state evolved by reliance on domestic courts. If there was a dispute, the state, through its sovereignty, its courts would effectively decide any disputes against the state, and effectively it would be the decision of domestic courts. The rationale was one of state autonomy. Governments should not receive local investors, local companies should not receive any lesser rights than foreign investors. You shouldn't allow investors from large, wealthy companies to essentially take over and undermine local companies. Local companies in Indonesia should not become supplicants, inferior to, subject to large foreign companies. That would effectively undermine the autonomy of the local economy, of the political system, of the sovereignty of the state, and the state's right, the state of Indonesia's rights to protect its own economy, its own citizens, and its own corporations. That was traditionally, and then changed to be a question of considerable controversy, which remains to this present day. And the controversy initially was developing countries that were in fact advancing and resented the situation where domestic courts would effectively decide matters against their interests. If you go to an Indonesian court, or if you go to a court in Ghana, or you go to a court in Bolivia, or in El Salvador or Ecuador, they will in effect decide based on local interests. In other words, they will be partial towards domestic interests and against the foreign investor. They didn't like that. The large major states of the world, the developed economies didn't like that. The investors didn't like it. So they didn't particularly care for domestic courts because they felt that the domestic courts that received investment from the large, powerful companies would effectively be prejudiced, biased in favor of developed countries and their investors. So what we have is a series of countries withdrawing, and I'll show you the map, withdrawing from the international treaty program, withdrawing from investor-state arbitration. And the first one you can see on the map is Bolivia. Then you see Ecuador. Then you see Venezuela. And then you see the Argentine, basically the Argentine Republic, really concurrently or close to concurrently with South Africa. And then it spreads, you've got Australia, and then you've got suggestions of withdrawing. Its only suggestions, and I have to correct, I've written quite a lot and had involvements in Indonesia. Indonesia did not reject investor-state arbitration, despite what was said, but it did express considerable reservations, and it indicated it was going to withdraw from a large number of its investment treaties. India also expressed their concern. The Philippines did. There were quite a number of states elsewhere. And since this map was prepared, beyond Romania. And in the vast majority of cases, the motivation was either having lost the state, unlike the cases to date, the state lost claims. The investors were successful, and that caused massive economic chaos in these developing countries. In the case of the Argentine Republic, it was absolutely devastating, and what is referred to as sovereign debt in Latin America was crippling. So these countries desperately did not want to rely on investor-state arbitration because they felt that this advantaged investors from developed states against their interests. In the case of South Africa, there was a similar concern because they lost a case. In the case of Indonesia in 2014, the Churchill mines case had not yet been decided, but Indonesia was concerned because there was so much involved that they were worried that if they lost it, it would push the economy into a retreat. They actually won the case in the end, but nevertheless, they talked about terminating their 67 bits and withdrawing from the exit, from the International Center for the Settlement of Investment Disputes. They threatened to do so. In the end, they did not. They withdrew from quite a lot. They withdrew from the Netherlands-Indonesian bilateral investment treaty, but what they were more concerned was revising and reformulating their investment treaties and not getting rid of ISDS, investor-state arbitration in all cases. And that is what's not understood, that in fact the intention in Indonesia was not to do away with ISDS. It was rather to have a greater degree of control over their operations on grounds of regulatory autonomy, on grounds of the sovereignty of the state of Indonesia. Australia, interestingly, walked the line and changed positions. In 2011, they said, no more ASDS. After that, a year or two later, they said, well, we will allow ISDS in some cases and in some not. So in the Kuliah agreement, Australia, there was ISDS. In the agreement with Indonesia, Australia, Indonesia, there was ISDS. But in the agreement with Japan, there was no ISDS. So effectively, Australia took a piecemeal approach. They took it case by case, and some treaties provided for investor-state arbitration and others did not. And that is significant to note. Now, in effect, what happened in the case of both Indonesia and Australia, the states actually won. Even though Indonesia spoke very negatively about the loss of national autonomy, of state sovereignty, by virtue of these claims, the investor-state claims, they nevertheless won the case. And similarly in Australia, despite their worry about Philip Morris, a powerful multinational corporation, securing advantage of Australia and its government, Australia won that case as well. Now, similarly, I should mention, it used to be that developing countries were the ones that argued against ISDS. They were the ones that suffered the most. Today, there are lots of developed countries that also worry about ISDS. I'm a Canadian by nationality and an Australian, and Canada has a significant concern about ISDS. It has lost quite a few cases, for example, to Eli Lilly, which is a large drug manufacturing company, and I've spent quite a lot of time in Canada even recently discussing how the Canadian government can deal with ISDS, given the fact that it has lost significantly as a result of foreign investor claims. So it's developed countries, not just developing countries, that are suffering at the hands of foreign investors. Similarly, Germany lost the Vattenfall case, which is a large hydro power case. They lost this against I believe, Swedish company, a Scandinavian company, and the award against Germany was $2.2 billion or euros, I think dollars, a massive loss for Germany, and there's a large, powerful Western liberal state that loses to foreign investors. So it's no longer just an issue for developing states, it is an issue for developed states and a worry about losing claims to foreign investors. Okay, now this is a bit of a backwards forwards. There are strong arguments in favor of domestic courts and strong arguments against. And I just pause at this point before I do this and just say, do we have any questions that I should be looking at? I've got no questions that I could see, but let me pause just to see and encourage people to put comments forward, because you're going to get very tired of hearing me all the time.
All right, Professor Trakman, thank you. It is very interesting. Actually, my students ask personally to my chat box, so that is why perhaps you do not see whether they could raise their question orally, so not writing.
Oh, I see. Okay, I understand.
Okay.
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 So interrupt me at any time, because often the questions are relevant and to that discussion, and I don't want to lose those students, largely because I'll lose the questions and we'll have to go back and people may not remember. So I'm happy to be interrupted at any time.
Okay, so at the moment we stop in the slide about domestic court, this kind of thing. Okay, I will remember. I stop share first. Just a moment. Stop your slides. So now, anybody? Who's that? Maheswari, do you like to raise question now? Are you there? Yes, speak up. We cannot hear you. Are you still mute? No, sorry. Yes. Okay, try to speak.
Thank you for the opportunity, Bu Atifa. Good morning, everyone. Good morning, Professor Trakman. I have two questions that I will deliver to you. Firstly, are there any criteria in the ISDS clause of a BIT or FTA to determine the amount of damages remedies submitted in the investor's lawsuit against the host state? Bearing in mind that this could provide a substantial potential loss to the state, the host state. And secondly, regarding the foreign state immunity, is that will be a significant obstacle to enforcement of awards. What should tribunals do if state parties refuse to comply with their decision? Thank you, Professor Trakman.
Okay, those are several questions and they're very good. I'm not sure I heard everything, so you can add as I go on. The first is the investor-state agreements, the treaties very often do not provide for the remedies. They simply say that the tribunal can arrive at a remedy. And you're absolutely right. Very often things like costs are enormous. In the case of the Churchill mines, there were millions of dollars in costs. In fact, the costs of the state were high and the costs of the foreign investors were high, lawyers' costs, etc. And in the end, the tribunal simply said, well, the claimants lose, the claimants have to pay for the government's costs and their costs. So the solution with regard to costs is left to the tribunal, and the tribunal decides, and again, on what criteria, and very often it's law that is contained or impliedly contained within the treaty. So very often, what actually happens is the tribunal relies on the law of the applicable state, the choice of law, which in the case, for example, of Churchill Mining was in fact Indonesia, that and in combination with international investment law, the broad corpus of international investment law, which includes customary law. And that will influence the tribunal in reaching a decision on the nature and extent of the remedy. Now, international investment law, as we know, is a little bit diverse because cases are ad hoc. So that is a problem where you say, what is the international jurisprudence? You say, well, according to this case, that, according to that case, a little different. And then you have this tension between what in fact is the applicable law. But subject to the choice of law and the overriding broad umbrella of the somewhat uncertain international investment law, the tribunal will arrive at the applicable remedy. That's in answer to your first question. Your second question, you asked something as well. Just qualify that again.
The second question, I was asking about foreign state immunity. So is that will be a significant obstacle to enforcement of awards? And what should tribunals do if state parties refuse to comply with their decision?
Okay.
That's all.
Okay, I think I understand. I'm a bit hard of hearing. I should be wearing my hearing aids. I left them upstairs. The upshot of it is, if in fact the parties refuse to comply, ordinarily today they will revert to the enforcement by the winning party, either in the jurisdiction or in some other jurisdiction where the goods are, where there are goods to attach, if you want. So what will happen is there will be an attempt to invoke the authority of the ICSID, the International Center for the Settlement of Investment Disputes, which is a large body which actually presided over the Churchill Falls case versus Indonesia, or the UNCITRAL, which presides over many other cases. They will effectively, they have procedures that provide for the enforcement of awards. Now, does it sometimes fall over? Yes. However, I don't want to be too cynical, the Trump-like moves of the last 4 years isn't usual, and most often states will and investors will comply, largely because reputational damage, economic instability, and probably a degree of distrust will occur if they don't. But very often they have to be able to attach property in the jurisdiction. And states in the existing jurisdiction, i.e. the state loses, let's say Indonesia lost, let's say Australia lost, then there are ways in which states will refuse and can refuse to decline or to enforce the awards. They will effectively try through their courts, through objections, to prevent that. And you said sovereign immunity is a classic example. We're immune. Now that's late in the day because the case is already the decision has been rendered, and presumably they raised sovereign immunity in their proceedings. So to raise it after the fact as a basis is hard to do. But that still doesn't mean that a domestic court couldn't find some other reason to limit the effect of the award in restricting the state. Similarly, a foreign investor, if it's an American investor and there are assets of Indonesia in the United States, they may try and attach the assets of Indonesia in the United States as a way of enforcing the award. And those can lead to conflicts. And that can lead to what is a particular problem. We do have an international convention on the recognition and enforcement of foreign judgments, but that has very, very few state adherents. I don't believe there's more than a dozen. We have the Convention on the Recognition and Enforcement of Foreign Arbitration Awards. That's mostly commercial, not exclusively, and there are in fact remedies, but in my view, there are limitations with that as well. So both very good questions. And in the second case, less evidently a problem, but I think underneath it is a problem. Investor wins, states say, bye-bye, we don't want you here anymore. That's a form of punishment. Can you stop that? Not really. Does it happen? Yes, all the time. That's an example of what falls outside of law.
Thank you so much,
Thanks.
Professor.
You're very welcome. Good, very good questions.
Thank you. Thank you. So, Rosa, do you like to raise the question?
Yeah,
Go ahead.
I'd like to ask Professor Trackman, please. Thank you.
Sure.
Yeah.
Go ahead, please.
Yeah, Professor Trackman, thank you for the opportunity. And I would like to ask you about the, according to the CPTPP, the Comprehensive and Progressive Agreement for the Trans-Pacific Partnership, it is stated that the ISDS provisions do not apply to relations between New Zealand and Australia. I would ask to would there be any potential problems that could lead to a bad partnership, or there are already a problem? Thank you very much.
I lost the last part of that. You were talking about the Trans-Pacific Partnership Agreement, and you're saying that ISDS does not apply to Australia and New Zealand in their mutual relationships.
Yep.
Yeah, okay. I'm a new Australian. I'm predominantly Canadian, and Australia and New Zealand regard their relationships as being very much part of the same extension of the same country, and they have their own treaties, and very often they have trust and reliance in each other's courts. So the result is they have an inclination in their mutual relationships to rely on each other's courts. And very often in New Zealand, Australian courts are quoted, New Zealand courts are quoted here, and it's looked upon as our brothers across the Tasman Sea, Australia and New Zealand. So that's a particular kind of situation where they don't feel they need the ISDS. They can rely on the pre-existing treaties, and they have quite a few, and they are not going to rely on ISDS. For the rest, ISDS is prevalent across the Trans-Pacific Partnership Arrangement. What we're going to see now is possibly the United States under the Biden administration rejoining the Trans-Pacific Partnership Agreement, in which case it will take over from the RCEP, which has just been signed off as the largest trade agreement, multilateral trade and investment agreement anywhere. ISDS, it would seem, will remain the primary mode of resolving disputes. That does not mean that there won't also be provisions for domestic courts to decide, i.e. very often you prevent it from relying on ISDS until such time as you have exhausted local remedies, until such time as you've engaged in negotiation, mediation, or conciliation, or there's a waiting period. You cannot proceed to investor-state arbitration until 6 months, whatever, from the time of the claim. And these are all ways of limiting racing to arbitration and encouraging the parties to resolve their dispute without conflict, and also respecting domestic remedies and very often domestic courts. So it's not always one or the other, domestic courts versus investor-state tribunals, but very often domestic solutions lower down doesn't work to the satisfaction of the parties, or issues where the parties prefer to pass over it than investor-state arbitration. Thank you.
Right. Thank you very much.
You're extremely welcome.
That was interesting. Yeah. Thank you.
Thank you for the question. Appreciate
it. Any other want to raise question orally? Okay, if not, I will read some of the questions written, some of the reasons because they have a problem with their mic, something like that, or perhaps they are not that confident to speak orally. Okay, one question was from Angga Alim Prasetya. Can investors who invest in the public capital market I think a stock exchange, perhaps he means. Yeah. When there is a dispute, sue the host state through ISDS. Are you following me, Professor Drama?
I'm having difficulty. You're saying, sorry, can I possibly get my hearing aids if I may? I'll show you how to put in hearing aids for future reference. Sorry, just try again.
That's all right. Yes.
Just say again if you can.
Yeah, slowly. So there is a question. Can investors, foreign investors, who invest in the stock exchange sue the country through ISDS?
Oh, a good question. Ordinarily, and again, there may be exceptions, ordinarily not. The stock exchange is regarded as essentially a private exchange. It's clearly public, but it's a private exchange. It's the free market, so to speak. You buy and sell stocks and shares over the stock exchange. Therefore, the stock exchange is not effectively a trade or investment with the government itself. So effectively, transacting on the stock market would not in fact involve the Indonesian government or the American government as such. So you could not ordinarily expect that to occur. Simply by virtue of the exchange of stocks on the market, because that's deemed to be the private domain, whereas the state is the public domain.
Okay.
And for those of you who don't know, these are called hearing aids. And these are fairly modern ones. And if any of you want them, I can recommend suppliers and such. Sorry, I'm just being just joking. Okay, go ahead, whatever you have, more questions.
Okay. Okay, so thank you for your answer. So, yeah, because we do have cases where the Indonesian government was recently sued by the investors, but the investor who bought the Indonesian bank through the stock exchange. So, but yeah, I agree with your point that ISDS mostly deal with the foreign direct investment.
Yeah,
okay.
There could be exceptional cases through the stock market, but ordinarily it would be very unusual.
Yeah, okay. And then question is that another one. Here, just mama, plenty. Okay, here it is. Okay, there is a question. I will read that. In the presentation slides, in your presentation slides, you says that both Australia and Indonesia would not longer include ISDS. But then again, using a domestic court has its own flaw and plus and minus.
Sorry, domestic court has? I didn't hear that. Has?
Yeah, but using a domestic court has its own flaw.
Yes.
Yes. Plus and minus. And we all know that using ISDS to solve a dispute is not the cheapest way to solve the dispute. So Adam's question is there any other option for the investors to make sure that their right is protected by law and to make sure that both parties, I think here in the both parties are the host state, usually developing countries, and the investor can be relieved from the high cost to settle dispute in the ISDS.
Yeah.
And then second, will, in your opinion, will the decision for this alternative way be the same as the quality to the ISDS decision? Thank you from Adam.
Okay, that's an extremely good question. It's something I'll deal with a little bit later on.
Okay.
But no, I think it's relevant, particularly relevant now. The options usually, historically, have been given courts or ISDS. Courts can be very expensive, particularly in expensive jurisdictions. So, for example, courts in the United States can be quite expensive. That's always a high cost. Arbitration tribunals can be high cost because there is a common set of fees that international investment arbitrators can charge. And they are cumulatively quite high, in addition to all the costs of the hearings, and because the cases very often take a long time. We don't really know, for the most part, the costs of judicial proceedings. In most jurisdictions, that's not public information. We assume what those costs are likely to be, but we don't know. We can today find out more about the costs of ISDS. And contrary to the traditional argument that they were lower than judicial costs, that probably is the contrary on average. They are generally very high. The idea of arbitration was expert arbitrators versus generalist judges. Arbitration was more expeditious than judicial proceedings. Arbitrations were expedited. Arbitrations took account of both the public interests and the economic interests. A lot of these are false. Arbitration on average is very expensive, and that is a real problem, particularly for poor investors or investors that are not multinationals, and also for states, developing and particularly less developed states. And that is an ongoing problem with any form of contract. If the other party has more money than you do, then you're in serious difficulty. That is an ongoing reality. Now, solutions for those very often are difficult to come by. One was proposed in the multilateral investment agreement by France in the middle 1990s. And the idea is, if we can have a multilateral agreement, we can possibly address some of these cost matters. Now, that never happened. The international community of states did not adopt the agreement, so we don't have an international template that deals with costs. The alternatives that are most often used is you have to use alternatives, very often preliminary remedies, before you revert to arbitration, which may or may not include, these alternative remedies may or may not include courts. So effectively, negotiation is supposedly a lot cheaper. Mediation or conciliation are also deemed to be cheaper. You do have to pay for the mediator, you do have to pay for the conciliator, and there's time and there's rental, and there are certainly decisions that the parties have to make with the advice of the mediator or the conciliator, but those costs are less. The problem is, very often if one party has more money than the other, the foreign investor, they will decline to use these remedies and they will push it to ISDS. So for example, if I'm Philip Morris and you represent and you are Uruguay, I know I've got much more money than you have. So I'll pretend or take very, very lightly negotiations because I don't really intend to limit myself to negotiations. I'll go through mediation because that is expected of me, but really my intention is to go to ISDS. And what I'll do is just, play along, talk to you, whatever, but I really want to go to ISDS because I think I have an advantage. That is the problem. And that is a problem that concerns many developing states, but that's also a concern of investors who aren't multinational international corporations. And I do not have a good answer to how one can address that properly, because very often to the rich go the spoils, and that is the nature of the so-called democratic economy, the free and democratic economy. It's not really about whether you have the money to use, it's rather you're free to use whatever you have. And unfortunately, very often that's not enough to defend yourself. So my answer is a very cautious and concerning one because I don't have a really good answer. Thank you for the question.
Thank you. Another one from Kuliah, Winda Kuliah, Class D. So the role of arbitration bodies is increasingly needed because of the increasing number of cases, especially in ISDS. So her question, what are the factors causing the increase in ISDS cases, especially during the pandemic situation like right now?
Yeah. I think it's a very important question, and let me posit this. I've been working in the area quite a lot lately, and it's speculative at the moment. There is an increase in IDS, there's no question. The increase in IDS is because there are more and more disputes. States are becoming more isolationist, more protectionist. They are effectively terminating relationships with foreign investors. They are attempting to avoid entering into new ones or continuing existing ones. Foreign investors are also trying to withdraw from agreements because they don't have the resources. The issues around loans, there's issues around employment, there's issues around access, isolation, inability to travel, the failure to secure supplies. All of these effectively have impacted upon markets generally, and in causing economic and social chaos, they're also causing conflicts to occur. We don't know how extensive these are yet, but they are growing. The arguments that are very often used is force majeure. There's a greater force. The pandemic is beyond everyone's control. It was unforeseen, and it didn't occur because of anyone's fault. That works to a point, but agreements that are terminated sometime after the event, after the pandemic, it becomes more difficult to argue force majeure. And that is a current predicament for those that are using that as essentially their primary argument. The issue, again, is, as all the issues before, we always have historically had crises. We had the financial crisis in 2008, 2009. We've had crises periodically through the last 30 years, economic, social, political, health. We've had pandemics before, and some people will say, what's new? This is a particularly dangerous one, but we've had at least one other that's probably more dangerous in the 20th century. And of course, in the past, the Black Plague, etc., was massively devastating. In these cases, you would say, we don't know yet what's going to happen with ISDS. Are there solutions? I think there's increasing pressure to streamline ISDS, to provide its accessibility, to make sure it operates fairly, transparently, even-handedly, that it protects state interests and investors' interests at the same time. But very often in times of emergency, like the present, where we want to have reform, there is difficulty in securing reform. In other words, countries dig their heels in, investors dig their heels in, and the result is they cannot reach agreement on how to solve the problems. And that's what I think is the current predicament, unfortunately. Thank you. Thanks.
Yeah, okay. Thank you, Professor. There is a question from Surya Aji. In the scenario when a foreign investor breaks a national law of the host state or act irresponsibly in its economic or business activities, can the host state or the citizens from the host state use the ISDS mechanism to sue the foreign investor? Thank you to the professor for the time and answer.
Okay. It's conceivable that local citizens could proceed, but they would not proceed through ISDS. they would proceed, since they are private citizens, unless they are state-owned enterprises, they would ordinarily proceed through litigation or international commercial arbitration, which is different from international investor arbitration. So that would ordinarily be their recourse, but they certainly could proceed if they have a direct cause of action. In other words, if they are directly impacted by the dishonesty, by the theft, by the corruption of the foreign investor, they can proceed by those means. The state can also proceed, and a lot would depend on what the treaty provides. If the treaty provides for ISDS, it is conceivable that a state could invoke it. The vast majority of ISDS cases, however, are brought by foreign investors. States usually act, and then the foreign investor complains. So in the case of the foreign investor that engaged in this illegal action, the state acts, and the foreign investor then proceeds to ISDS, which is exactly what happened in the significant Churchill mining case. There was the state decided that there was in fact fraud on the part of the foreign investors' local constituent company, which was an Indonesian company. They decided that there was fraud, illegal action. The government then terminated the licenses of that company. The government acted. There was a fraud. The government acted, unsigned documents, and the government cancelled the licenses. And then the foreign investors proceeded and said that what the government had done was against the rule of law, which was against due process, denied them substantive rights, etc. So very often what happens, and where governments believe there is illegal action in the state, they exercise their authority as governments under the treaty, which is expropriation and expropriation-like remedies, in this case, cancelling licenses, expiration licenses, and then the foreign investors sue. That's the ordinary way it happens.
Okay, so is it clear, Surya Aji? All right. And any question if somebody want to raise orally or directly? Who? Okay, if not, I will continue with another question. Here, a question from Professor Anselmo Reyes. So the recent fair and equitable treatment decisions suggest that tribunals are moving toward treating the fair and equitable treatment term as calling for a proportionality assessment of state conduct. Do you agree with this trend, or do you think that fair and equitable treatment should simply be treated as introducing a vague minimum international standard? If you agree with FET being construed as importing a proportionality assessment, do you envisage that more and more states will be deterred from entering into bilateral investment treaties or multilateral investment treaties? Thank you.
Thanks very much. Alsama, that's a hard question. I expected you would ask me a hard question. Let me answer in this way. I don't know that there is, for me, it's not an either or, largely because I'm probably a functionalist and I look at the circumstances before I take a choice or make a choice. My own view is the fair and equitable standard is, particularly by its very wording, open-ended, but so are many others. The capacity to use it in many ways is a benefit and a problem. The benefit is there are always unique circumstances, and the fair and equitable standard of protection can address that. My own worry is that high level of flexibility, while it's sometimes beneficial, on other occasions it tends to be excessive on the one hand or minimal on the other. I think the argument of proportionality then is stronger. If in fact you use a fair and equitable test and the fair and equitable solution is somehow proportionate, and again hard to measure, is proportionate to the issue, the harm, the loss, the cause, then I think that is a constraint upon what could amount to a rather open-ended and unclear use of the test. The worry that I have is proportionality itself is a quantitative standard. And very often, a lot of the issues translate into qualitative issues. Now, you can say that this action on the part of the government or this action on the part of the foreign investor does have a financial value, and therefore you can quantify. My own sense of it is the equitable, free and equitable standard invites qualitative criteria to be used as well. If that's the case, proportionality can become more complicated, and it can also become more artificial. So my answer to Anselmo is, as you would probably identify until now, is yes and no. I think the arguments for both approaches, it's hard for me to choose between them in the absence of a particular context. I think sometimes the proportionality approach works well. In other times, I query whether it is too arithmetic, too mechanical, and perhaps loses the flexibility, the fluidity of the fair and equitable test. The problem is the fair and equitable test can be abused, misused, misunderstood, misapplied, and can cause a lot of vagueness because it can operate in multiple different ways in multiple different cases. That is a risk. But similarly, the use of equity in common law is a typical example of common law having massive variations in the scope of equity. So it's not something that law and regulation doesn't already have. Broad, open-ended standards directed at due process, fairness, very often by their very definition, involve the potential to expand upon or contract the scope of words like fairness and, in particular, equity. Thank you.
Thank you, Professor. So there is a question from Donna Triputri from class D. Good afternoon, Professor Drachman. My name is Donna. I want to ask about court fees. Court fees in ISDS. There is a fee that must be based on the state if the arbitrator receives the full claim from the investor. But what happens if the state refuses or incapable to pay the court fee? What are the consequences, considering the cost could be very large? Thank you, Professor Drachman.
Okay, a good question. In the vast majority of cases, states do pay the fees, but conceivably they may not. This could lead to further remedies, mostly enforcement proceedings. And enforcement is something that very often takes place either at the in the jurisdiction where unfortunately where the state, the host state is located, or elsewhere where they have assets. And effectively you would attempt to arrive at a remedy which would effectively cover the costs that the foreign investor has incurred that the state has refused to pay. That can happen. The vast majority of states do pay because of the reputational and other damage. They don't want to drive away foreign investors. Developing countries need foreign investors. Developed states need foreign investors. So anything that looks as though they're taking an aggressive approach where they're refusing to pay, the decisions reached by tribunals could be interpreted as a negative sign for any potential foreign investor. Why invest in a state that will not respect its international obligations? That seems to be the concern, and that's why I think states, for the most part, comply. Thank you.
Thank you.
Sure.
Another question related to COVID. And then this question is from, just a moment, from Windya Adinda Putri, class C. The impact of COVID-19 is that many countries from all over the world are taking action in the economic sector to suppress the spread of COVID-19. Governments have rushed to impose quarantines, travel bans, additional visa requirement, export restriction, and etc., which is sometimes detrimental to foreign investors. In this pandemic situation, can investors challenge COVID-related actions imposed by the government under investment law-based ISDS clause?
I think that is a growing concern, and it is already surfacing. I was approached about a case that's moving in that direction, and it also occurs in international arbitration more generally between companies that are impacted. The answer is yes. A foreign investor can always lodge a claim. The issue is, can it be successful? And the key criteria of this: to what extent is the state acting, quote, legitimately? To what extent is the state representing the public interest, public policy, national security, in effectively imposing the restrictions, increasing the licensing requirements, denying import and export licenses, refusing to allow foreign employees to enter the country, controlling the amount of finances going in and out of the country. Those are all the criteria that you would have to consider in deciding, was the government's actions in accordance with the risks created by COVID, and alternatively, are they excessive? So, for example, if in fact a government, let me give you examples that I know. Australia is comparatively COVID-free relative to the United States or the UK. And a lot of countries in Asia have not suffered severely. We have a great deal of variation from one state to another. Victoria had the most deaths by far, but over the last 17 days, they have not had one contracted COVID case. South Australia, on the other hand, that had a COVID-free record since April, has suddenly had a significant number of cases in the last week and a half. Now, each of these states have reacted differently. And the argument is, if the state closes the borders, if the state refuses to allow foreign ships to arrive, if the state refuses to allow foreign airplanes to arrive, if the state refuses to allow people to go to work in each of these cases because of COVID fear, because of public interest, will people say, well, other states have taken a different position. They've said, as long as we maintain wearing masks, as long as we have isolation, as long as we have observation, testing, checking, then we're okay. And then the argument is the one state acting excessively carefully, like Victoria, Melbourne in Australia? Are they acting excessively carefully and hurting the interests of foreign investors unduly because they don't need to be that careful? Or alternatively, are they acting appropriately to stop further outbreaks? If, on the other hand, a state does what is happening in the United States and is completely open, no masks, no limits on contact, wide open gatherings in places where there's no restriction or unenforced restriction on gatherings, is that state engaging in an unduly pro-investor stance, which causes public risk. So the state is in a very difficult position. If it acts unduly cautiously, then conceivably it is hurting the interests of foreign investors. They can not only make a claim, but they could conceivably win. If, on the other hand, it's acting without without that caution, well, then foreign investors are very happy because they have access. They can come and go. They can fly in planes. They can bring in workers. They can arrange for the offices to be full. And that's the contrast. So the real risk now is all cautious states engaging in conduct which amounts to excessive caution at the expense of foreign investors, and should those states be held liable for acting in violation of treaties and contracts under those treaties.
Okay, thank you. Thank you. So, clear for Winda. So, any other questions before Professor Trakman continues? Because we don't realize that we almost reached the end of, we almost reached at 12:15. Anyway, so is there any more questions? Okay, so so Professor, do you like to continue your presentation?
Sure. If you could put me back on, and I'll continue.
Okay.
Thank you.
So
Thank you.
Hold on.
Sure.
Yeah. Okay, everybody could read.
Okay, I'm going to move along.
Slides.
Thanks. Well, I'll move along this fairly quickly because we are moving along time-wise. Why not domestic courts? We've discussed this to some degree, and there's enormous debate on this. The clear concerns are different states have different laws, different states have different traditions, different states have different rules of law traditions, rights of hearing, rights of representation, etc. And different states have different conceptions of public policy. In fact, the same states have different conceptions of public policy, and some people would say, what is public policy? It's like sucking your thumb and putting it out to the wind. We don't really know what it is. So these are all problems about domestic courts. Now, this heading that you have, perceived deficiencies of domestic courts, that is actually a little bit, I think the title should rather be choices between domestic and international investment law is probably more appropriate. And the question is, if there's an international investment law, if there's international investment legislation, investment codes, treaties, international investment principles, customary principles, should that prevail as a matter of choice? Now remember, in the case of Churchill mining, the court, the tribunal, and a very strong tribunal, took the view that both Indonesian law and international investment law applied. What about making a choice between them? Now, the argument is international investment law is unclear. We talked about it, ad hoc, one case to the next. But the problem is domestic law is unclear. Variations, one state to the next. So that doesn't particularly help you. Now, Indonesia has a particular example we discussed, but I'll mention it in additional details. Indonesia, at the time, 2015, was very concerned about, in particular, the issues around cases like Churchill mining. Indonesia, like many countries, was worried that they were going to lose ISD cases and that there would be pressure on the economy from foreign investors. So they indicated they were going to move away from ISDS, and they were going to rely on alternative remedies. They never really did that. They did, in fact, include ISDS in a number of treaties, as we've mentioned, including Australia. In addition, which is very important, you can eliminate ISDS in your treaty, but the vast majority of treaties have what's called survivorship clauses. So even if Indonesia, as it did, terminated its Holland, Netherlands, Indonesia treaty, it could still, investors could still, under a survivorship clause, proceed against Indonesia for 15 years. So you don't stop that from happening. Now, what is the benefit of ISDS? And this is an area that is often argued about. IDS are experts. The tribunals, can we go back to that for a second? IDS, can we just move back to that slide just for a second?
Okay.
No worries.
Is this one?
No, just to go ahead.
Go ahead. Or go ahead. Okay.
Next one. Sorry.
Okay, that's all right. This one? This one?
No, go back one, go back. I'll just go on where it's getting confusing. Okay, the benefits of ISDS, let's stay with this one for a bit. Maybe I'll just tell you when to move on. Now go back to that one before, to go back to the one before, and I'll just mention it. The one before that, just to go back and stay with that. No, the one before.
Yeah. This
the one before. No, go on one. No, why not IDS is what I want. Why not IDS?
Why ISDS? Is this the one?
No. Stay with it. That's it. Stay with. Okay, leave that as is, and then I'll tell you when to make the other. I just want to discuss this briefly. Okay, why IDS? Why ISDS? The argument is it is a single procedure, and in itself it can be binding. It doesn't rely on diverse national decisions of local courts. It is a single international solution. It doesn't rely on state-to-state diplomacy, which is very often secret, subjective, and amounts to bullying, what we call gunboat diplomacy. It avoids the problem of many domestic legal systems. There are international conventions that govern ISDS, like the ICSID and the UNCITRAL, and 158 states have already endorsed ISDS, so there's a lot of affirmation of IDS. That's great. If you go to the next one, that'll be great. Thank you. Next slide, Viva. There you go. Okay, I think we can skip this where we discuss that. Okay, the benefits of ISDS is the parties can choose the arbitrators from panels, and their panels include ISDS in the ICSID or UNCITRAL. The permanent court has panels. They can choose the arbitrators, or they can make ad hoc decisions. They can choose arbitrators that are not on panels. The arbitrators historically were viewed as prejudicial because they were concerned most about commercial expertise. They were essentially perceived to be pro-investor because they were commercial experts. Now the view is there is more public law expertise than there was before on these panels, and public law expertise very often translates into an understanding of government public law interests. Then there's also regulatory bodies over investment state arbitration, such as the Administrative Council of the ICSID. The UNCITRAL also has a secretariat, and they effectively provide guidance, administration of proceedings. There's also a greater degree now, not historically, of publicity associated with arbitration, including public proceedings where you can attend and publish awards. We still talk about their lack of uniform jurisprudence because the cases are ad hoc. There is no, in effect, IDS precedents, but we do refer to them as authoritative. Okay, now we can move on to the next one, that's okay. Okay, I'm not going to spend much time on this. We've already discussed them. There are deemed to be a lot of deficiencies with IDS, bias, favoring developed states is historical, and that was certainly in the claims of the Latin American states that objected. There's no appeal process, which I haven't mentioned over here. There's no appeal from an IDS decision. There's no appeal court. There are very, very limited annulment proceedings. The argument is that very much favors investors. The remedies favor investors, and the protections favor the investors. That's the view. That was clearly the case historically. Investors won far more often than they lost. Developing countries lost far more than developed countries where they were targets, and that has changed significantly, but not entirely. A majority of developing countries still do less well than developed countries, but it's no longer as one-sided as it was before. As far as the quality of proceedings are concerned, the issue is, as I mentioned, investor arbitrators very often lack historically public law training. They were trained in business, and that was perceived to favor commercial foreign investors. Amicus briefs, which is the invitation of a brief from interested parties, was excluded, and many arbitrators, and I find this very funny being an international commercial arbitrator, were involved in what we would refer to conflicts of interest. I will be writing articles to support my position. I'll be consulting in order to build my reputation as being an arbitrator favoring a particular point of view. I will take on private clients. So essentially, I sell myself as somebody who has an agenda. Rather than seem to be fully impartial, I have a particular agenda. Now, I've not experienced that myself with many arbitrators. I found them to be fair-minded, but there was the view that arbitrators were not impartial and they were engaging in conflicts of interest. So we can move on to the next one. Afifa, if we could just go, okay. And going forward, I think a key issue is, and these are very, very difficult ones to state, we have to somehow find a way to recognize the private interests of foreign investors and reconcile that with the public interests of states. That is easier said than done, and we live in a world of what I would call Westphalian tribalism. States increasingly want to insulate themselves. Brexit in the United States, Trump-like isolationism, countries around China and Russia that defer to China and Russia or don't. These are all indications of inward-looking protectionism on the one hand. On the other hand, there are strong pushes towards internationalization. These are very, very strong movements that are not easily reconciled. And I think that is the case with international investment disputes, but it's also the problem with international trade. Anything that requires cooperation and collaboration across boundaries runs into difficulties. Another serious problem, particularly involving China, but not only, is state-owned enterprises. China has many state-owned enterprises, and the question is, are they validly foreign investors, or are they really arms of the state, and should they be treated as arms of the state? Very, very controversial and not easily resolved. The rule of law, again, what does it mean? We know what the British mean by the rule of law. They embody it in their Magna Carta of 1215, but it means very, very different things in many different jurisdictions, even though we use the words very often quite freely. The issue is the divide between in confidence. We don't want to reveal our secrets as a company. It'll undermine us. Governments, we don't want to reveal national security issues. On the other hand, if this case involves an investment and the investment impacts on the state at large, surely the public has a right to know. That's an ongoing tension, privacy versus public right to know, not easily resolved. Public participation in proceedings, can you, as a member of the public, an interested member, participate? Should you be able to? What are the limits? Highly confidential. And then the question is, should the awards be prepared and available to the public as a whole or only in redacted form, i.e. with elements removed? Now, I've been a NAFTA panelist for many years, since 1992, and the redacted information, the redacted decisions very often made it almost impossible to read them, because a lot of the important information was withheld on confidential grounds. And that is a problem with reducing the content of what the public sees. Thank you. You can go on. Thank you. Okay, recommendation. Strictly speaking, we need balance. We have to protect fair and equitable and national treatment. It's important. On the other hand, we also have to recognize national security, public health, environment, safety, and also financial security. That is an important balance, not easily achieved, but a priority. We have to recognize that dispute avoidance can move in stages. You don't have to resort instantly to arbitration or courts, but you can move to the earlier stages of mentioned, negotiation, mediation, etc. Waiting periods before you can invoke ISDS or litigation, also very sensible. And having to exhaust local remedies before you resort to arbitration is also a way of limiting the prospects of disputes. We can go next one, thanks. Okay, structural reforms. Very briefly, before everyone falls asleep, I'm going to just briefly mention the structural reforms. Should we change access of investors, foreign investors, to claims? In Philip Morris, what caused a lot of grief in Australia and Uruguay was that Philip Morris, which is an American corporation with large investments in places like Ukraine, needed a way to sue, for example, Australia. And it found a very, very useful treaty it could use, which was the Hong Kong-Australia Free Trade Agreement. So what it did is it set up facilities in Hong Kong, and it used Hong Kong as a jurisdiction from which it could lodge a claim against Australia. And a lot of people said, well, Hong Kong is really a jurisdiction of convenience that Philip Morris is creating to allow them to proceed. It's essentially what's called forum shopping. They're looking for a jurisdiction with an investment treaty that they can take advantage of, even though they don't have any other involvements in Hong Kong, a concern. Interim measures. Is it possible that you can limit state intervention by providing interim measures? In other words, we don't leave the status quo until the entire dispute is resolved through ISDS. We have temporary measures that are put in place, so it's not an all or nothing solution that could take 3 years or 4 years to arrive at. And then costs, very important. One of your colleagues raised it. How do we monitor costs? How do we stop them becoming excessive? An extremely difficult problem, including for administrative tribunals like the Exit Secretariat. Interpretation of treaties, the argument is we should have, as they have under the NAFTA and under the NAFTA's successor, a body that interprets the treaty. That would be very helpful, and it would provide for additional protections for the parties in allowing them to plan on the basis of treaties. Social impact studies also very important. Important to know what the impact is going to be on society of different kinds of decisions infecting, protecting the environment, employment, etc. What are the social impacts of claims that fail or succeed? Those are important criteria. And I think that's it. So if there are any final questions, I'm happy to address them.
Thank you, Prof. Trakman. Any questions? We still have, let's say, 5 or 7 minutes left.
May I ask a question directly, ma'am?
Yes, sure. Go ahead. Thank you.
Good afternoon, Professor Truckman.
How are you?
I read an article about ISDS, and it explained about some ISDS deficiencies, including that many ISDS cases are increasing numbers against health and environmental laws, including laws to address climate change. And ISDS are secretive, that until now, the laws in the tribunal set up under ISDS provisions has been a secret. Therefore, how does ISDS process ensure that it could provide effective ways to settle investor-state disputes without undermining the health and environmental laws? And how about the ISDS transparency? And I have my second question. One of the ISDS deficiencies.
Why don't we just answer them one at a time, because my memory won't remember the second question. So let me just deal with the first one. So
Okay,
the
thanks.
first question you asked is, how do we provide a greater degree of protection of public health where we have transparency, where we know that the decision is publicly available, known and appreciated and understood, as well as we know the reasons that are given for the decision? Is that basically the question? Or have I missed it?
Oh, yes.
Oh,
Yes,
okay.
yes, sir.
Okay, look, until about 10, 12 years ago, ISDS was completely secret. It was regarded as a closed book. The public didn't know. There was an outcry. Many developing countries felt that it favored corporations, foreign investors, because they would say it's all a matter of commotion and confidence. And the result of it was very much in favor of wealthy investors at the expense of domestic states. They lose, and nobody would know because of secrecy what the basis for the case was. That has changed over the last 12 years. The ICSID, for example, has radically changed their transparency requirements. There's now public access. There's now amicus briefs, public briefs that are heard. People can actually be involved in hearings. Awards are published, particularly in areas like public health for the reasons you've given, safety and security in the broader sense that you've identified. That is still not a full solution. Privacy is still preserved, and both governments and foreign investors do claim the right to a security of information. They still claim privilege, and they still claim confidentiality. As well, very often proceedings, if you are attempting to participate, are very controlled. You're not allowed to participate at different stages. If the tribunal decides that they're not willing to have you there, because the party, one or other party, has argued that this is not for public disclosure, public interest and other group organizations are not allowed to be there. Similarly, the awards can very often be redacted. They can be reduced to remove information. All of those limit access to information, participation, and understanding of how awards are reached. And that is a limitation. It'll never be completely eliminated, but it is nevertheless still a problem. So if you ask me the second question, I can respond to that.
May I ask my second question?
Sure.
Yeah. And one of the ISDS deficiencies that written on your slide is investor-state arbitrations bias favoring developed states and their investors. Has this issue been resolved, and how does the ISDS process ensure that in the future the arbitrations is unbiased?
I'm sorry, I had difficulty hearing. What did you say the very first? What's the slide you referred to? What did I say there? Sorry.
One of the ISDS deficiencies is investor-state arbitrations bias favoring developed states and their investors. Has this issue been resolved, and how does the ISDS process ensure that in the future the arbitrations is unbiased?
Okay. Are you following her? Could you understand?
When you say deferring, you mean the who defers? I didn't quite follow.
Yeah. So basically, she asked, Intan asked, in her perception, there is bias. There is bias that ISDS prefer more investors who come from developed countries.
Sure. Okay, look, that is an ongoing question. One of the areas that I've made part of my career out of, because I write a lot about it, and that's an area where I've been involved in professionally as well. And it is a massive problem. Is there bias? Yes. There's lots of evidence, not so much bias in the form of decisions that are deliberately reached in order to benefit foreign investors, but because the process advantages them, it always did. Historically, ISDS was the choice of dominant exporting states, Western developed states, long before China became the great power that it is, long before less developed states became developed states. And in effect, what was happening was ISDS was a vehicle by which foreign investors protected their interests in developing states from states that would attempt to regulate them on grounds of national interest, etc., public policy. That was historically the case. There have been efforts to remedy that, to reduce that bias, to appoint more public interest arbitrators rather than commercial arbitrators, to have more balance, to appoint more arbitrators to panels from developing countries than developed countries, to appoint, interestingly, more women to arbitration tribunals than historically was the case. Those are institutional changes. Structurally, there have also been attempts to modify the procedures for conducting arbitration to ensure more transparency, i.e., the ability to participate, the ability to know what the case is that has to be met, the admission of evidence from third parties that was otherwise excluded. That's another way of addressing the bias. Yet another way is tightened up procedures. And that is the development of supervisory procedures. And many of these administrative bodies, the so-called secretariats, such as under the ICSID, they are there to guide the process. And there are rules within these organizations that have been effectively liberalized to provide for a greater degree of transparency and reduce the bias. Can we eliminate the bias completely? Probably not. Has it been addressed to a degree? Yes. Is that enough? We can talk about that for another 2 hours. And there are many cases we'd say yes, and there's some cases we would say no. So again, I cannot give a absolutely convincing answer, except to say there's a very high level of consciousness of the issue. Thanks. Good question.
Thank you, Professor.
Okay. You're welcome.
Any other question? Dianda?
Yes, I have a question.
Sure.
Related to the slide of recommended BITs and FTAs clauses about the waiting periods before ISDS or litigation. How long exactly these waiting periods before ISDS or litigation? And if in that term there's a problem that has impact to one of them, how do you handle that? Is it make the waiting periods more longer to wait before ISDS or litigations? Doesn't it make some losses for both sides because the matter is still on process?
Okay. Are you following her?
Not adequately, no. My hearing aids aren't helping. So
Yeah.
Go ahead. Yeah.
I will explain, Dianda. Don't worry. Yeah, because I think there is also noise in the background, your background. Anyway, so basically she asked about one of your slides in the recommendation for BIT and FTA clause about waiting period before ISDS or litigation. So her question is, how long exactly this waiting period before ISDS or the litigation? And if in that waiting period there is a problem, how to handle that? Is it make the waiting period more longer to wait? And then does the waiting period make the both sides will lose because the problem keeps going on? Basically, it is her question. Is that right, Denanda?
Yes.
Yes.
Okay, good question. It's a good question. And in a way, there are a lot of people that would answer your question by saying that the waiting period only achieves a delay to encourage the parties to agree, but there's no certainty. In fact, very often, it's unlikely the parties will actually agree within that waiting period. The most common waiting period is 6 months. And the argument is, you've got 6 months to sort it out yourself. Try to resolve it, see if you can reach a remedy. If you can, it'll save a lot of money. It'll avoid a protracted dispute. If you want to get a mediator to help you, or conciliator, by all means do so. And the argument is very logical. It makes perfect sense. But if I'm a wealthy foreign investor and I'm determined to have my way, or I'm a state and I'm concerned about public reaction, I play to the audience. I want to get people on side. I want to be re-elected. So I dig my heels in, or the foreign investor digs their heels in. And then what happens as a result is the 6 months go by, they may talk to each other, they may have a mediator, but the truth of it is one or the other party is really unwilling to settle. So effectively, after 6 months, the claimant can then proceed to the claim. And very often it's the claimant who doesn't want to settle in that waiting period. It's the claimant who wants their day because they want something more than what the state is willing to give them. But very often the waiting period can be helpful, and we don't know about it because a lot of this is not public, because in the waiting period, the foreign investor says, I may lose. The government says, I may lose. Problem. Both of them, money and reputation. And then other arguments are, well, maybe we can reach a remedy that makes both of us happy. And that's another answer. So how many cases are in fact resolved in that waiting period? Quite a lot. And some of them never are formally filed as disputes under the appropriate treaties. They are effectively dealt with in a background fashion. So there are cases involving countries like China, not China and Indonesia, but China and some surrounding countries, construction cases, one that I'm familiar with, where in fact the case disappeared. The parties resolved. Exactly what they did, we don't know. But clearly, either the investor was intimidated because China doesn't back down readily, and why would they, nor does the United States, nor the Europe and British, they probably accepted something of a deal. Now, the deal may have been better for the state than for them, but it never went further. So I cannot tell you the result of the case other than it was settled. Is it a good thing? If there's bullying going on, maybe not. Settlement saves time, reputation, and maybe survival for, in that case, the construction company. I simply don't know. But I think it's a good question nevertheless. Again, very hard to answer. Thank you.
Okay, thank you very much. To be honest, there are still 2 or 3 questions, written one, but I'm very much afraid that the time I have to close the session because the Zoom will be used by another program. Anyway, but I do hope, so this is the proof that we have to continue our cooperation, Professor. So this is not the first, well, this is the first, but not the last class from you, I hope.
Yeah. Thank you very much. It's been a great pleasure. I think your students have asked brilliant questions, and I liked Osama's question. I've learned a lot. I've had a lot of fun. And I would certainly be very happy to have further engagement. It's a real pleasure. A real pleasure. And you've done a super job in convening and organizing everything, for which I very much appreciate.
Oh, thank you very much. So I also thank so much for my students' presentation. you represent, the good one of Faculty of Law Brawijaya University. So somehow you bring a good fame or good name of Brawijaya Law Faculty, I hope. And I hope that the Professor Traxman class could inspire you to write articles or even your thesis, right? Because his subject is very important in this 21st century. So don't write the same topic all the time, okay? Write something challenging like what Professor Traxman already introduced to us today. Okay, so now the class of Professor Traxman has come to an end. So on behalf of the Brawijaya Law Faculty, all of us would like to express our gratitude for Professor Traxman's guest lecture. And I hope all of us could gain useful knowledge from his class. And those who give give questions that perhaps have not been addressed today, I hope that the next time with Professor Traxman, you could raise again, you could participate again. And so thanks so much. And for those who have classes after this, you may leave the Zoom. And please don't forget to fill in the presence list that I already shared with the coordinator of each classes. So thank you so much. And Professor Leon Traxman may take a good rest, have a good rest after 2 hours. And also thanks for other guests, Mr. Rockwood, and also Professor Anselmo Reyes, Nobumichi. So before we close, could you please give thumb ups in your screen? Thumb up, okay? Thank you very much. Bye-bye, and see you next time.
Assalamualaikum. Thank you very much. Thoroughly enjoyed.
Thank you. So I will write to you later, Professor, regarding things. Okay.
Thank you so much.
Nobu. Finally, after how many years? 2 years. I saw you, Nobu. I do not know if other Nanda. Where is Nanda? Do you remember Nanda? She was here, but yeah, Nanda.
Oh.
Yeah.
Oh, yeah. Oh, okay. Well, maybe next time we'll talk. Thanks very much.
Bye-bye.
Okay, bye all. Bye.
Bye. Terima kasih, Maeswari. Pertanyaannya, Dianda membawa nama baik fakultas. Makasih Bu Hanif. Makasih Bu Ranitia.
Iya, terima kasih sama-sama Ibu.
Maaf
makasih,
ya,
Bu Afifah.
Ada pertanyaannya mahasiswa Bu Hanif belum terjawab. Aduh, saya mendulukan yang ini tanya langsung tadi.
Iya, enggak apa-apa Ibu, nanti di kelas akan saya lanjutkan pertanyaan ini.
Makasih.
Menarik.
Makasih Bu Zora, makasih Bu Cindy, sampai ketemu lagi. Terima kasih Bu Dian.
Ya, sama-sama Bu. Ini